Navigating the complex world of child protective services can be overwhelming. Today, we're diving into a critical topic: foster care and prevention services contractors. Did you know that child protective services agencies rely heavily on private contractors for foster care and prevention services? This means that while you may initially deal with a CPS investigator employed directly by CPS, most of your case could be managed on behalf of CPS by a nonprofit contractor. While some contractors only provide foster care case management or prevention services, most have separate contracts to provide both. Government employees are expensive and often unionized, making them extremely difficult to terminate. Outsourcing to private agencies also reduces the responsibility and liability CPS has for legal violations, maltreatment, and other issues in foster care or in the provision of prevention services. These benefits are what entice CPS to turn to the private sector for foster care and prevention services, which, while expensive, are cheaper than CPS providing these services themselves. These contractors are often nonprofit agencies classified under 501c3 or 501c4 by the IRS. 501c3 organizations are charities that provide services to benefit the public good, while 501c4 organizations serve the public, but donations are not tax-deductible. Most CPS contractors are 501c3 charities under the old classification for Societies for the Prevention of Cruelty to Children, the predecessors of Child Protective Services as we know them today. But some are 501c4 social welfare organizations. Different from 501c3 charities, 501c4 social welfare organizations undergo less scrutiny, can donate to political campaigns, and are not required to disclose their donors, except to the government. When your child is taken into foster care, the assigned foster care case manager likely works for a contractor paid by CPS, not CPS itself. These contractors are responsible for home visits to the child or children and the biological parents, case plans, and court reports, which CPS assumes to be accurate. When a child in foster care is maltreated, the foster care case manager doesn't do what they're supposed to, or another issue arises. CPS can be ignorant of it if it's never reported. If they do become aware, they act shocked, surprised, and revoke the agency's foster care contract, giving the contract to another agency to appease public outrage, until it happens again, and CPS plays agency roulette. Prevention services is outlined in the Family First Prevention Services Act, funded mostly by Title IV-E of the Social Security Act, and touted as evidence-based services superior to other services for child welfare-involved families, to either prevent involuntary foster care placement or promote reunification, are often provided in-home by contracted agencies. Prevention services providers are also mandated reporters, and among the most aggressive reporters of subsequent reports to CPS. This creates an environment where the family is constantly under surveillance, and the slightest failure on the family to meet the standards of CPS could result in another investigation, and the possibility of a cycle that leads to perpetual CPS involvement. On top of that, very few of these prevention services are considered to have evidentiary support by the government's own measures, and as listed in the Title IV-E Prevention Services Clearinghouse. Like with foster care case management, when a child is maltreated, the prevention services provider doesn't do what they're supposed to, or another issue arises. CPS can be ignorant of it if it's never reported. If they do become aware, they act shocked, surprised, and revoke the agency's prevention services contract, giving the contract to another agency to appease public outrage, until it happens again, and CPS plays agency roulette. When your child is placed in foster care, the foster care case manager, along with a guardian ad litem, court-appointed special advocate, or both, are the only consistent sources of information to the court on the child, especially if the parents' counsel is not actively speaking up and submitting motions. That means what they say or don't say hold a lot of weight with the judge. In court, prevention services may be the only options allowed if you don't beat CPS to finding and enrolling in an equivalent service first. If CPS recommends prevention services before you have equivalent services in place, the court is highly unlikely to accept any alternative you propose. In the United States, more than 1 in 3 children will face CPS involvement at least once before the age of 18. Don't wait until CPS shows up. Don't wait until your case is taken to court. Don't wait until your family is ripped apart. Don't be one of those parents who ends up saying, "If I knew then what I know now, I'd still have my child." At CPS Protect Consulting Services, we prioritize avoiding court altogether and alternatives to prevention services. Navigating a CPS case successfully is extremely difficult, but not impossible with the right assistance and strategy. Visit cpsprotect.com or call us toll-free at 844-633-KIDS. CPS Protect Consulting Services, saving children, preserving families.